All right, here we go. Hey, tomorrow's a big day. We're going to find out who Trump's pick for the Supreme Court decision is, the Supreme Court replacement. So we're going to get into that a little bit, a very little bit. Mostly what I want to talk about tonight is the Supreme Court itself. How, what it is, what it should be, what it was, and kind of how we got to the point that we are now. So buckle up. All right, here we go. So tomorrow night, 2100, 9 o'clock, for those of you with a half clock. The Donald is supposed to announce who his nominee for the Supreme Court is going to be. Personally, I'm kind of pulling for Ms. Barrett. Amy Barrett, the Andrew Clavin did a bit about it the other day. It's time we had a hot chick on the Supreme Court. Okay, that's all well and good. That's cute and funny, but the idea of having a conservative woman on the Supreme Court, I also like, because let's face it. With okay, Ginsburg is her gender, and I'll get into more about what a monster Ginsburg is, and how she is an active enemy of the people of the United States and an opponent of liberty, and freedom, and the American dream. But Justice Sotomayor, good God, that woman is just, the word racist gets overused because people apparently have forgotten what it means to be a racist. But the statement, "My judgment as a Latina woman is better than the judgment of an old white man," that's racism. That's textbook racism, and obviously sexism. She literally stated that her ethnicity and her gender made her intellectually superior and more fit for the job than another person who was of a different race or gender. That's racism and sexism. Period. Okay? So she shouldn't be on the Supreme Court anyway. And when you part of the job description is to be an unbiased interpreter of the law. Sotomayor and Ginsburg clearly are not that. So, and then with Amy Barrett, the other picks are, I'm less excited about them. I really like the idea of Amy Barrett, in large part because I'm enormously pro-life. People who argue for infanticide and call themselves pro-choice, to say that you are pro-choice and you're arguing for infanticide is to be a liar. It is to speak untrue words. If you argue for infanticide, you are arguing for the ending of a life. Now, let me just remind you real quick that way back when we had slaves in this country, the Democrats argued then that it was okay to enslave blacks and Irish because they were not people in the same way that whites were. Okay, it was, and Chinese, by the way. It was okay to enslave the lesser races because they were not people and did not have human rights. Through hard work, dedication, and a fucking civil war. Yes, I'm a Southerner. I'm proud of my Southern heritage. I love the South. I love my native Georgia clay. But And let's be real, slavery was on its way out for economic reasons to begin with. But the argument about personhood that strong Republican work defeated in order to free the slaves, that is the same argument that is made to support the position that infanticide is morally tolerable. It is okay to kill babies because babies aren't people. That is the extent of your argument. Of course, other arguments for the murder of babies are, well, people who live in poverty can't afford to support and raise children. Okay. So as someone who is frequently accused of being a Nazi because I believe in liberty and freedom and fair choices and equal treatment under the law and the recognition of Israel as a state for the Jews, and of course that makes me a Nazi, and I believe that no matter what color a man is, he deserves equal treatment under the law, not only as codified by the Constitution in its amendments, but generally. Of course, that makes me a freaking 1344 Nazi. So as somebody who is obviously a Nazi, as you can see from my shaved head, let me just point out the argument that that poor children can be killed because they're a financial burden. You are arguing for eugenics. You are arguing that we can improve our society by exterminating the poor. Now, often on the right, the argument is made that churches and private organizations are better at dealing with poverty, or better at distributing needed goods and services, and even financial aid to the needy, those that I like to call the less adequate. But private organizations, churches, and the like, are far better, and this is not an opinion. It is not an opinion that they are better at doing it. It is an absolute, documented, statistical fact. They're better at distributing welfare-type services and products than any government bureau can be. All right. I kind of lost my train of thought. All right, bear with me. Supreme Court, abortion, yada, da-da-da, da-doo-be-doo. Yes, so we're accused of not wanting to take care of the children because we oppose government programs like the welfare state and so on and so forth. Oh, you're pro-life until they're born, and then you just don't care because you don't want to give them free medical care and free this and free that. No. We're saying there are systems in place that do that, and when you use a bureaucratic administration to do that, you have to spend $1 on an administrator for every dollar that helps a person. And that is an extremely conservative and generous estimate, by the way. It's more like $3 to $4 in administrative cost for every dollar that actually serves a person in need. Okay? So that argument's off the table. That the conservative is not interested in the welfare of the children, off the table. Especially when you look at the scandalous things that are going on in adoption legislation across the country, where these bizarre leftist groups are going out of their way to shut down faith-based adoption agencies, arguing discrimination. And you know what? No, shit right up your nose. If somebody is giving up their child for adoption and they want good things for their child, it is okay for them to prefer a certain class of people to raise their children. Now, I almost fully concede that when you give your child up for adoption, you've given up your right to make choices on that child. I almost fully concede that. But before you have given your child up for adoption, which I'm not a big fan of, I've got 3 babies, I can't imagine letting any of them go. I understand that circumstances arise and circumstances can be complicated. I cannot imagine not being prepared to murder every other living human being for the sake of my child's welfare alone, if it came to that. Obviously, it's a hyperbolic and extreme example, but not entirely out of the question. Stranded in a hostile place with my children, for the sake of their safety, I will orphan your villages with a toaster and a bedsheet. But I understand that there are circumstances where you just can't raise the child. I'm not real sympathetic to the idea that you were too poor to raise a child and you were out getting pregnant, despite the risk to the child that you may or may not end up having to raise, because you made the choices. Pro-choice. You made a choice. You dropped trowel. You made a baby. You made the choice to make a baby. So that's the end of your choices. Once you have created a life, that life has its choices, and you don't get to make those decisions for it. Especially when that decision includes whether or not to put a gun in its mouth. All right. Now, while I've gotten down this road a little bit deeper than I expected to, it's only been 10 minutes, but a little deeper than I intended to on the abortion issue, as an abortion issue, without even getting to Roe v. Wade yet. But the left likes to argue that the murder of a child is a woman's right, that somehow that has to do with women's health. Okay. To the extent that being pregnant is an issue of women's health once the choice has been made to become pregnant. And no, I do not exclude unplanned pregnancies from the blanket statement that getting pregnant is a choice. All right? We're not going to talk about life of the mother exceptions and pregnancy from rape exceptions, because they are extraordinarily rare. Okay? We do not extrapolate a rule for the vast majority, the 90+% of cases, based on the exceptionality of exceedingly rare circumstances. A life of the mother case, you're no longer talking about the question of abortion. You're talking about the question of, if you have 2 lives which cannot coexist, and one must be chosen. I don't think the law has any business in that. If you tell a woman with a child that she now has to choose between her life and the life of her child, you have just placed an impossible decision before a mother and father. And they do need to make that decision together. That is a very, very, very hard place for a person to be. And as to the question of rape victims, I mean, it's so exceedingly rare that it is the case that a child is the product of a rape, compared to the nearly 4,000 abortions that are committed each day. That the question of the rape baby should be handled entirely separately. there may be a better case for the argument. And hey, I'll confess this. In the case of a rape child, to argue that a woman has the right to choose whether or not to keep her rape baby is an argument for eugenics, because what you are choosing then is to assume that the child carries the, let's say, psychopathic or sociopathic genetic material of the rapist, and it is beneficial to the society to exterminate that genetic material. Okay. In a sort of a cold way, I can kind of get behind that. But the vast majority, nearly all cases of abortion are related to the simple choice. The simple, I don't want to have this baby because I'm not ready to have a baby. Well, sweetheart, if you're not ready to have a baby, you're not ready to make a baby, put your pants on and go to work and make some money and then go have a baby. Plus, 9 months is a lot of time to get ready. 9 months is, you find a job, get your shit together. But you made a decision. You got pregnant. Now, why am I talking about abortion when this episode is about to be about the Supreme Court? The lefties are obviously losing their ever-loving minds over the idea that Donald Trump gets to appoint another Supreme Court justice, and that justice will be a conservative justice. Now, they lost their minds over Scalia getting replaced with Gorsuch, which is stupid. Scalia was easily one of the greatest justices to ever serve on the Supreme Court. An absolutely staggering intellect. Just an intellectual giant and a constitutional textualist. Brilliant man. I absolutely encourage everyone to hop on YouTube later and find anything, especially Uncommon Knowledge interviews with Justice Scalia. Brilliant man. But he was replaced by Gorsuch. Well, so the conservative justice got replaced with a conservative justice. The balance did not change. Now, Roberts, who has just announced his retirement, has been largely conservative except on social issues. And yeah, we're going to end up talking about gay marriage a little bit tonight too, because I have a real problem with the Supreme Court decision on gay marriage. Now, that's a very careful sentence, and it's important. It's important to note. I have not said that I have a problem with gay marriage. That's not the point that I'm making. I'll get back to that in a minute. Yeah, so my wife just commented, was he a paragon of unbiased legal force? Yes. Conservative justices are by definition a paragon of unbiased legal force. And this is actually, I was just about to transition into this part of the conversation, this part of the topic anyway. Conservative justices are unbiased interpreters of the law. The question, when you're talking about Supreme Court justices, the question is not whether they are conservative or liberal. The question is, are they Constitution readers? Are they textualists? Or are they not? There are only two ways to interpret the Constitution. There is a correct interpretation, and there is an activist anti-interpretation. Scalia was one that correctly interpreted the Constitution. What I mean by this is not, I agreed with every decision he made. That's not what I'm talking about. The Constitution is a document in black and white. It has words which have meaning. Those words are not difficult or opaque. The meaning of the Constitution, when you read the Constitution, the meanings of the words are not some ephemera. They're not some mystical, bizarre, extraneous twisting of the language. They are plain English. They're older English. The language has changed over time, some, but they are written in very precise language. They don't just have clear meaning, they have exact meaning. And what that meaning is not only enshrined by the words in the Constitution itself, but described and debated and elucidated in explicit detail by the writings and the communications of the signers and the drafters that originally created the document. We know what the Constitution means. One of the clearest examples of the point that I'm making is the case of Heller. In Heller versus D.C., essentially the Heller case was brought over the D.C. law concerning the ownership of firearms. And in Washington, D.C., up until Heller, essentially the way the law worked, I'm drastically oversimplifying this because it's kind of the minutia of the decision that I want to talk about, not the law in the D.C. law in general that I want to talk about. But essentially, the law in D.C. at the time said, as a private citizen, you may own a handgun, but that handgun must be stored in your home, locked in a safe, and the ammunition must be locked in a separate safe. And as Cameron and I were saying when we were discussing this earlier, if you own a firearm and you have it locked in a safe, and you take the ammunition and you lock that in another safe, and if I remember correctly, the safes were required to be some distance apart from one another. If you have a gun locked away from the bullets, you don't have a gun. Okay, that bizarre law essentially prevented people from having a firearm at their disposal for any purpose, let alone self-defense. So, the Heller decision struck that down. Now, what's really telling and terrifying about the Heller decision are the dissenting opinions, which included Ginsburg, by the way. Ruth Bader Ginsburg signed on to the dissent in this case, and my timeline might be a little bit off, but I believe Sotomayor was also a signatory to the dissent. But the dissenting opinion in Heller was not that it was okay for D.C. to have a law which was so offensively limiting to a person's free right to keep and bear arms. No. They went the full boat further down the road. The dissent in the Heller case was that the Second Amendment does not imply a right to keep and bear arms for the private citizen. They went so far as to argue that private citizens should not be allowed to own even sporting rifles or shotguns. Nothing. They went so far as to say that owning any firearm for any reason was not a protected right of the people of the United States of America. That as citizens, you should not even be allowed... And let me be very, very clear. Their argument was not that the Second Amendment did not protect your right to keep and bear arms. Their argument was that the Second Amendment reserved the right to keep and bear arms exclusively to the military, not the unorganized militia, not the organized militia, but the official military and the police. And that if you were not a member of the armed services or a sworn deputy or some other member of law enforcement, that you were not permitted the ownership of a firearm of any sort. So their argument was actually not only that the Second Amendment did not prevent the government from preventing you from owning firearms. They went so far as to argue that the Second Amendment prevented citizens from owning firearms. That was the dissenting opinion in the Heller case. Now, of course, the opinion of the court in the Heller case, thank gods, is that citizens absolutely have the right to keep and bear arms. I would have gone a bit further, because in the Heller case they did talk about things like sawed-off shotguns and restrictions on the ownership of machine guns and things like that. And of course, I would not permit such a restriction. I would go so far as to argue that the Second Amendment absolutely extends to tanks and what have you. For example, quite recently, I'll give you a case, quite recently with the, forgetting her name now, the Department of Health and Human Services lady that got thrown out of the restaurant. The great big crowd of protesters went and surrounded her private home and screamed at the house all night. Now, I'm an amazing shot. I terrify professionals at the level with which I obliterate the enemy when I pull that trigger. I once told an old sergeant major in Afghanistan, brother, if you can't kill a man with iron sights, you don't deserve to carry a rifle. And I could not step out my front door with a 30-round magazine and defend myself effectively against a horde of 1,000 or 1,500 violent left-wing assailants bent on doing me harm. Nielsen, I think that's right, babe. Nielsen, that sounds right. So Nielsen, if we've got her name right, which I'm not entirely certain of, and I'm sorry, but she should absolutely have had every right in the world to have claymore mines deployed in her yard. And I don't have claymores in my yard, and even if the law permitted it, that's a lot of work to go out of my way to do. But if I'm a public figure and suddenly a mob is here to cause me harm, why shouldn't I have every right in the world to step out my front door with a 240 Bravo firing 7.62 by 308 at a couple of hundred? God, I'm forgetting my numbers now, but anyway, why should I be able to step out the door with a 240 Bravo and mow him the fuck down? Why should I submit myself to the slings and arrows of an angry mob come to do me harm without my invocation? Ludicrous. But the activist justices who choose to interpret the Constitution incorrectly, and it's quite obviously incorrectly, there is not a reasonable argument that can be made to support the dissent argument in the Heller case. Rod says stinky stuff. I'll get back to that. There's not a reasonable argument that can be made to support the dissent in the Heller case, because the founders very clearly explained that the word militia, as used in the Second Amendment, right, a well-regulated militia being necessary to the freedom to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The militia, that word, a well-regulated militia, that word militia, coupled with the words well-regulated, have been, for some reason, a kind of rallying cry for the leftists to argue that the Second Amendment doesn't guarantee the right to the people. Guys, there is one sentence, and that sentence has an operative clause, which is separate from the sentence. And that operative clause is dependent on the sentence. If you take away the right of the people to keep and bear arms shall not be infringed, it doesn't make sense. It is not a sentence. A well-regulated militia being necessary to the security of a free state. That's not a sentence. But if without that clause you say the right of the people to keep and bear arms shall not be infringed, that is a sentence, and that sentence makes sense. Oh, well, why do we even mention the militia then? Because the militia, as defined by the signers, as defined by the founding fathers, and they referred to it as the unorganized militia. The unorganized militia is every man, every able-bodied man between the ages of 16 and 60. In the Militia Act, that's federal. And that man between the able-bodied and between the ages of 16 and 60 is required to own a firearm. Now, that hasn't been... And you're required to have a rifle, keep it in good order, and to maintain ammunition for it. That's right, you cannot get rid of militias without a constitutional amendment. I might actually go so far, Rod, as to say that it's almost impossible to... It would almost be impossible to get rid of militias with a constitutional amendment. That would be an interesting conversation, but I'm gonna have to get back. I'm gonna have to go away from that for now and finish this thought. So that's what an activist judge looks like. They look at the Constitution and they say, I don't give a shit what this says. I'll just make some shit up. I'll just do what I want to do. So let's talk about Roe v. Wade. Roe v. Wade, what's very important about Roe v. Wade is, and we're talking about this in particular because the lefties are terrified that a new justice, a new conservative justice is going to tip the balance of the court, and they're going to overturn Roe v. Wade. Okay, for one, I don't actually think that's going to happen. I don't actually suspect that we're going to overturn Roe v. Wade anytime soon. Gods, I wish we would. Okay. And we're just talking about gun control. You know, if we ban all the guns, there won't be any more school shootings because criminals obey laws. Oh, but if we outlaw abortions will still continue to happen illegally. They'll just be less safe, but they'll happen illegally. Oh, and if we enforce the border, people are still going to come across the border. So if we make a law, criminals are still going to do crime, unless it's a law you like. How about this? How about we stop the gun violence by making murder illegal? Okay. So, Roe v. Wade, by the way, does not make abortion legal explicitly. Roe v. Wade took the issue of the legality of abortion away from the states and to the Supreme Court. Roe v. Wade, even if you are a pro-infanticide leftist, if you cannot concede that Roe v. Wade is a bad decision, you're not paying attention. So, all the lefties that think Roe v. Wade is important and they want to retain Roe v. Wade because they just can't stop murdering their babies, because the Democrat Party just can't maintain its power unless it has the legal authority to sacrifice children to the god of ecumenical politics. the only thing that they understand about Roe v. Wade is that it makes abortion legal. That is incorrect. Roe v. Wade makes abortion federal, and there's a big damn difference, and that difference is incredibly significant, because in order to argue for a woman to have the right to murder her babies, the Supreme Court decision on the case had to argue that from the nebulous penumbra, yes, that is the language from the text, they had to argue that from the nebulous penumbra of unenumerated rights, which are retained by the people and to the state through the auspices of the 10th Amendment, that in the nebulous penumbra of unenumerated rights exists the right of a woman to murder her unwanted child. Here's the problem with that. The right of a woman to murder her unwanted child not being enumerated as a right protected from the federal government is, if one contends that such a right exists, reserved by the 10th Amendment to the state on which to litigate. Ergo, an argument, any argument, most especially the argument made by the Supreme Court, which permits the murder of your unwanted baby, is founded and grounded and established in the argument that decisions about that right are not enumerated to the auspices of the federal court, and therefore reserved to the litigation and legislation of the state's governments there beneath. Ergo, the question of whether or not a woman is allowed to murder her unwanted baby is exclusively reserved from the federal government, and they haven't the authority to decide upon it to begin with. Roe v. Wade is an unconstitutional decision, even if you can argue, even if you can find it in your soul, if you can shed enough of your humanity to argue that a woman should be able to murder her unwanted children, under the law, that decision is forbidden to the federal government. The Supreme Court never had any business deciding on that decision. That case should have been expelled from the court on the grounds that the plaintiff hadn't grounds or standing, and the court lacked standing. Now, where am I? Oh, okay. So, let's get to how that even happens. So, Marbury was appointed Justice of the Peace, Washington, D.C., by John Adams. And Madison had the responsibility to deliver the appointment and the credentials and the badge so that Marbury could begin to execute his duties as the Justice of the Peace. Madison didn't deliver the papers. It delayed and delayed and delayed, and Marbury took the case to the court and went to the Supreme Court. And, oh yeah, this shit matters. The Supreme Court, prior to Marbury versus Madison in 1803, had not the authority to overturn law based on constitutionality. The Marbury versus Madison decision was the beginning of the end. That was when the United States was first diagnosed with cancer. The Marbury versus Madison decision was the first diagnosis constitutional cancer. The court in this case usurped new authority, not delegated to it by the Constitution, and we have allowed this to continue, and now it is so ingrained that it's hardly reversible. But I do have a solution for that, and it looks like I've got 20 minutes to get through this conversation and discuss my solution to the question of constitutional review, judicial review. So, in the Marbury versus Madison case, Marbury had been appointed to be the Justice of the Peace. Madison drug his feet on delivering credentials. Marbury sued to have the court issue a writ of mandamus. Mandamus, to force Madison to deliver the credentials. The court found that Madison should, under the law, be forced to deliver the credentials, but then decided that the law, which created the power for Marbury to direct the court to direct Madison to deliver the credentials, was itself unconstitutional. So, basically, in the whole Marbury versus Madison case, I mean, this is judicial. Okay, mandamus. Jesus, Rod. You know how many words come through my teeth in the course of 1 hour doing this shit? You're lucky I get them all out in English. So, in Marbury versus Madison, I mean, I suspect a hint of pretty severe corruption, because the court said Madison should be forced to deliver this documentation and appointment so that Marbury can get on with his business. But then what they did is they overturned the law that gave Marbury the ability to basically to send the court to enforce the law. They just said, well, we don't want to enforce this law, so we're going to overturn it. And that was where they created this power of judicial review. They just made that shit up. Okay? The Supreme Court just decided that it wanted to be more powerful, and now it is too powerful. And here's why the lefties get their panties in such a knot over how the court is balanced. Like I said, it is not a question of whether it is a right or left interpretation of the Constitution. There is a correct interpretation of the document. It is an English document. If you're a native English speaker, you should be able to read the document and understand what it said. If you read the document and somehow manage to pluck from the ephemeral penumbra of unenumerated rights that a woman can murder her unwanted children for the sake of her own convenience, then you're a fucking liar. And what you are really saying is that you just want your women to be able to sacrifice their children to your god of ecumenical politics. So the court has become too powerful. The lefties are in love with the court because America writ large, for example, California's Prop 8 a few years ago. California, Prop 8, no gay marriage. I'll get the Supreme Court to say, no gay marriage, Prop 8. And they took it to a court and had it overturned, gay marriage in California. But the people voted in majority against gay marriage. Now, this is not my endorsement or dismissal of gay marriage, marriage equality, so and so, whatever. My absolute position on marriage is this. Marriage is a contract between two persons, and who those two persons are does not matter beyond the one question. It's a couple of questions, but are they consenting, informed, competent engagers in a voluntary contract? Age of majority, intellectual competence, informed consent, voluntary induction, contract. That's it. Now, if you do not define marriage as between one person and another person, then obviously you open it up to bestiality and multiple marriage, blah, blah, and hell, Heinleinian frickin' communal marriages where you've got 8 mommies and 12 daddies and nobody knows whose kids are whose because everybody's kids are everybody's kids. And that's how you end up with Michael Valentine Smith coming back from Mars and being eaten by the Horde. But, as far as the law goes, California did not want gay marriage. They voted it down. It went to the court, and the court said, we don't care what the people want, you're going to have gay marriage anyway. Gay marriage went to the Supreme Court, SCOTUS, and they said, we don't care what you want, you're going to have gay marriage anyway. So here's the thing on that, though. I have a real problem with the way the Supreme Court decided the gay marriage issue, because the Supreme Court unconstitutionally litigated extra-constitutionally. They litigated outside of the confines of their authority to create law for the states with respect to an issue that is not enumerated within the authorities delegated to the federal government by the Constitution. The question of marriage and of gay marriage is absolutely one that belongs to the states. And here's my real problem here. Gay marriage is a thing now, and that does not have to continue to be true. Since it was done incorrectly, the doing of it is vulnerable to a not very complicated undoing, also by judicial review, because the court has too much power. Well, the lefties love that the court has too much power, because, like in the case of Prop 8, their positions are not popular. Even with Obama in office, and for the short while that he had a majority control of the House and Senate in 08 and 09 before the Tea Party just ate their fucking lunch in 2010. And I'm sorry, I know I've been dropping an extra bunch of fuck bombs this week, but I'm a little bit passionate about these issues. They couldn't get anything done, and it's because America doesn't want their shit. So they crammed it through. They crammed abortion through by the Supreme Court instead of by the correct, legitimate process of litigation and legislation. They went through the process of litigation instead of legislation. They did not create law through the process of creating law. They magically poofed in some new law by having the court decide that the law existed. The court does not have the authority to make law. But the court has decided to usurp some of that authority. And so you get activist judges. You get stuff like Roberts essentially creating the justification and the constitutional justification for Obamacare, where it was clearly unconstitutional. There is absolutely nowhere with even the furthest stretches of the leftist frickin' happy balloon that is the Commerce Clause. It is impossible to argue that the government has the authority to command affirmative action. And I do mean affirmative action in the sense of the word, not in reference to the law, which is called affirmative action, although that too is an unconstitutional law. The fear is not just that Roe v. Wade will be overturned, but that the left will lose their private legislator. The left has come to use the court as their own private little legislator because they can't get their crazy neo-Nazi-esque socialist free healthcare, free college, free crap. We shoot all the rich people and take their money and squander it. Pearls before swine. Garbage. They can't press that through the Congress. Even with Barack Obama and control of the House and Senate for a couple of years, they could not press that shit through. And so they do it by usurping constitutional authority through the courts, especially the Supreme Court. Now, there were several very good, very correct decisions. Yes, when a Christian baker says, I refuse to create art at gunpoint, he absolutely has the right to do that. And to interpret that one has the freedom of speech from the First Amendment is a correct interpretation. To extend the interpretation that my freedom of speech equals my authority to compel your speech, that is activist. That is extending rights to authority. Rights are not authority. I have the right to keep and bear arms is not the same as me saying I have the right to murder you. I have the right to speak is not the same as saying I have the right to compel you to speak. I do not have the right to compel your speech. My rights end at your nose. I can swing my fist in your direction all day, but as soon as I pull it back sticky, I'm wrong. It's that fucking simple. So, make sure you tune in tomorrow night, and tune into something, not just here, but wherever. Catch the news. 2100 tomorrow night. The Donald is going to tell us who the new Supreme Court pick is. And that will be a very, very interesting development. So until next week, thanks for watching. I appreciate y'all hanging out with me. I love you. I need you. And I can't wait to do this again next Sunday at 8 o'clock. And until then, remember, if you build a man a fire, you'll keep him warm for the evening. But if you set a man on fire, he'll be warm for the rest of his life. Trump 2020. Good night. You're very welcome, Julie. Thanks for watching.